Hello and welcome everyone to Conflict Free Zone. Today I will have a distinguished guest all the way from Kenya, Mediator Edwin Apacha. During the next 20 minutes, we'll dive into the world of mediation in Kenya, how mediation operates, what types of dispute could be resolved through mediation, the principles of confidentiality, the qualification required to be a mediator in Kenya, and gain valuable professional insights from our guest. Now, without further delay, let's start. Afternoon,
Right.
Edwin.
Afternoon to you, Alibi. How are you?
Yeah, I'm good. Thank you for being here. And first of all, could you please introduce yourself for our audience and tell briefly about your experience and background?
Okay. My name is Edwin Apacha. I'm a certified professional mediator. I do court annex mediations and private mediations. Apart from that, I am also a mediation trainer, training people to become mediators. I also mentor them in their journey towards becoming professionals or experienced professionals. In a nutshell, that is Edwin. I have been a mediator since the year 2016. Okay. I guess now that's about 8 years thereabouts of experience. Yes. In a nutshell, that is Edwin Alibi.
Thank you.
Yes.
Because you are a mediator from Kenya, can we talk about mediation in Kenya? My first question, what types of disputes could be resolved through mediation in Kenya?
Okay. In Kenya, the sort of disputes that can be resolved through mediation, we have commercial disputes between entities or between various corporates having issues and they need to have their issues resolved through mediation. We have succession disputes. We have family disputes, land disputes. Those are very many, by the way. Land disputes, people are always squabbling over land, and yes, mediation offers a very good forum for those disputes to be resolved through mediation. We also solve a lot of workplace disputes. We have mediators being onboarded by organizations as neutral facilitators to help parties resolve disputes at the workplace, and also labor disputes, when maybe there are differences between employees, an employer, and an employee or a former employee. Before they move to court, they decide to try mediation first. But if mediation is not able to help them resolve their issues, then it's escalated to litigation. So in a nutshell, those are the sort of cases that are resolved through mediation in this region of ours. And actually, so to put it, probably about 80 or 90% of the cases that are filed for litigation are mediatable cases. Of course, like, not all matters can be mediated, right? Yes, in a nutshell, Alibi.
Is it correct to say that almost every civil dispute could be resolved through mediation?
Exactly. In a nutshell, that is what we are saying. Almost every civil dispute can be resolved through mediation.
Yeah, thank you. And
yes.
How parties typically approach mediation? Is it a voluntary process, or are there instances where mediation is required by law or contract?
Okay, in our jurisdiction, as far as court annex mediation is concerned, parties are directed to go for mediation. It's a court-ordered process. Parties are directed to go for mediation after the judiciary has looked at the matters and decides which one can go for mediation, which one cannot go for mediation. So more or less, parties are directed to go for mediation. But of course, they can be directed to go for mediation, but they cannot be forced to reach a resolution. Okay. And then for private mediation, it's parties who willingly come for those sessions. They approach you, the mediator, when they have an issue, and you basically give them a brief about mediation, selling the benefits of mediation. And if they are agreeable, then we proceed and do the mediation.
And how does the legal system in Kenya support or promote the use of mediation?
Actually, it is enshrined in our constitution.
Wow.
That alternative ways of resolving disputes are enshrined in the constitution. And these alternative ways we are talking about, of course, mediation, there's arbitration, there's negotiation, there's arbitration, mediation, negotiation, conciliation. All this is enshrined in the Constitution. So actually, our Constitution greatly advocates for parties to resolve their issues through mediation, through ADR, as opposed to maybe going to litigation. And for a good reason. We have a lot of backlog within our Kenyan judiciary system, and judiciary encourages resolving of issues through mediation as opposed to litigation. We have a very huge backlog. The judicial officers are overwhelmed with what they already have in their hands. And new cases keep on being filed each and every other day. So yes, highly encouraged by the Kenyan Constitution.
Thank you. And
yes.
Confidentiality. How is confidentiality maintained in mediation proceedings?
Okay, when you're doing your mediator's opening remarks, when it gets to talking about confidentiality, first you have to have a verbal confirmation from the parties that they are going to keep everything confidential. If they're in agreement, there's a document we call confidentiality and inadmissibility form. They append their signatures on that document to say, or rather to promise, that they are going to keep everything discussed there confidential. So we have a document that they have to append their signature on to abide by confidentiality clause of mediation.
Okay, I got it. And what qualifications are required to become mediator in Kenya?
Right. Initially, they would insist, or judiciary would insist, that someone has to have at least a basic degree. But they go to realize that there are people who can do very good or who are doing very well as mediators, yet they do not have that qualification. So they relax the requirement for a degree. So for now, basically anybody who has basic literacy skills, you're good to go. Then, of course, you undergo the 40, 50-hour mediation certification training, you're good to go. That's how it is, yes.
So this training is required, right? And what if person didn't take these trainings? Can he or she become mediator?
Basically, all of us have been doing mediations, albeit informally. But now if you have to do it as a professional, then it's mandatory that you have to undergo this training. 40-hour training, some institutions do it for 50 hours. So it is a must, yes, to have that certification as a professional. There's no shortcut about it.
Thank you.
Yes.
What is the consequence if one party breach a mediation settlement agreement?
Okay. The first thing that to let parties know when you're doing your mediator's opening remarks is that once they append their signature on the mediation settlement agreement, that document is binding and it's not appealable. And the consequences of not keeping your end of the bargain is that court can come in very harshly, maybe impose some fine of some sort, or commit you to civil jail, or make a ruling that will favor the other party against you. So people know that there are repercussions to not obeying what you've voluntarily appended your signature on in terms of that settlement agreement. Yes, so there are consequences, definitely. But in private mediation, it is up to the parties to decide whether they'll honor the agreement or not. But what we do as mediators, our constitution encourages, even if parties have reached a settlement through private mediation, they have a choice on whether they want to have it registered with court in case for enforcement. But if the parties are not willing to want it registered with the courts, so be it. Yeah.
Thank you. And so fascinating to hear some examples of mediation. And can you describe one of your most memorable mediation cases and without disclosing any names?
Okay. I think my most memorable mediation matter that I've handled was a succession issue. It had been in the courts, or it had been in for litigation since the year 1987. You can imagine how many years that was. And we only got to resolve it in the year 2019.
Wow.
The value of what this family was squabbling about was close to about $1 about $10 million. In Kenya shillings, that's about 1.3 billion. So they had been in court for a very, very long time. You can imagine from 1987, we got to resolve it in the year 2019. And I must say it is memorable because it is the mediation that has ever taken me the most time. We did 11 sessions. 11 sessions, each lasting about 3-4 hours. You'd make headway. Today, you make some progress. When you come back for the next session, parties are becoming difficult and holding on to hard positions. So I had to exercise extreme patience in just appreciating the baby steps that they were making. As much as we would go forward today in this session, the next session, we go back, we reverse the gains that we've already made. But eventually, I was glad that I was able to assist the parties resolve their dispute. And they were very, very, very happy. And they actually wondered, why were they not aware about the existence of mediation before? Because they've spent a lot of time in court. They've spent a lot of money on their advocates. And of course, as that was happening, their relationship was soured. And these are people who are supposed to be relatives. But at the end of it all, everything went on well. And yeah, parties shook hands. And they went ahead to implement what had been agreed in that mediation settlement agreement. I feel good whenever I remember that one, considering the time it had taken in court. Yeah, Alibi.
Yeah, it's a great case from 1987.
Yes, 1987.
And now moving to the next question.
Yes.
How we, like professionals in ADR, in mediation, can encourage people to use mediation?
How does? Sorry, I didn't get that, Alibi.
How can we encourage people to use mediation?
How we can encourage people to use mediation is first selling the benefits of mediation. For example, when you talk about confidentiality, parties are aware that in mediation, issues are going to be confidential as opposed to a public courtroom where you have everybody, you have the general public, you have the court officers. And when you talk about confidentiality, especially in family disputes, they don't want to air that dirty linen in public. So they'd rather have matters resolved through mediation. And then also, when you're trying to get a buy-in from people to adopt mediation, you also talk about expense. Mediation is definitely cheaper than litigation. Especially, you can imagine if a matter is going to be in court for those very many years, parties are spending money on their advocates. It's not cheap going through a litigation process. Then what else can you talk about? Mediation is faster than litigation. Like the example I gave you, if you want to have a buy-in for the people to adopt mediation, you talk about it being faster. The example I gave, the case that had been in court since 1987, we got to resolve it in the year 2019 after about 11 mediation sessions. These 11 mediation sessions took how long? Probably within 3 months, and we were sorted with that issue. So we try and sell the benefits of mediation for parties to adopt that. So what happens in Kenya? Our judiciary organizes for sensitization workshops to let parties know we have better ways, more amicable ways of resolving disputes. And us at a personal level as mediators, whenever you get an opportunity to speak to a crowd, wherever you are, so long as it's more than one person, you let them know about mediation. Even in churches, if you get a chance, you basically tell the congregation about availability of mediation. And yes, it is still not very many people know about mediation. It's work in progress, and we're working towards just making sure that a lot more people get to know about the existence of mediation. But we still have a long way to go, I must admit. You'll even get very educated people who do not know what mediation is. So yeah, it's not bad, but we are getting somewhere.
Thank you.
Yeah.
I told my mom about mediation. She asked, why are you like lawyer taking meditation case? Meditation?
Meditation. And so clear. Yeah.
Yeah, it was just fun because my mom didn't know about mediation at all. She thought it's some type of meditation.
We encounter that a lot. When you first talk about mediation, the first thing people think about is meditation. You tell them, no, it is mediation, not meditation.
Yeah, that's right.
Yeah.
And the last question for today, how do you see the future of mediation in Kenya? Do you see any potential developments that could change this field positively?
Yes, there are a lot of efforts going on towards sensitization on ADR. For example, in the court annex mediation program, as you know, when property is in dispute, nothing can happen. You cannot sell, you cannot access money in the accounts, nothing. But through mediation efforts, in Kenya shillings, about maybe 21 billion has been released back to the economy through mediation efforts or in matters that were previously in the court. But now through mediation, that money is injected back to the economy. And also our tax person, we call it Kenya Revenue Authority. They are getting to adopt friendlier means of collecting taxes as opposed to the adversarial means of wanting to sue you or auction you. They are becoming friendlier. Come here, let's have a chat. This is what you owe. How do you intend to pay? And parties willingly give out a payment plan that is friendly to them. So that is quite a lot of progress. And in terms of Kenya shillings, we have about 30 billion that has been injected back into the economy or that has been paid up by people who used to owe Kenya Revenue Authority. And people are voluntarily coming up to adopt that as a way of, just having an amicable chat with the taxman. And then most recently, we have the umbrella organization of financial institutions in Kenya. It's called the Kenya Bankers Association. Kenya Bankers Association is also increasingly wanting to adopt mediation as the first point of call, as opposed to, auctioneering and using all those adversarial means of, collecting debt. So that is work in progress. We've held very many high-profile seminars towards that end, and we hope that by the beginning of next year we'll have actualized this. Banks encouraging mediation or just having mediators, independent, neutral mediators coming in to have a talk between the bank on one side and the guy who's affected on this other side. Then something else. We're also having progressive institutions onboarding mediators, or rather having a panel of mediators having mediators in their panel. People to come in and help resolve workplace disputes, because of course, when you're having a workplace dispute, it's best that it's done by a neutral party, someone from outside the organization. So we come in as neutral facilitators and help resolve those workplace disputes. So in a nutshell, I would say in the Kenyan space, we are moving towards the right direction in just having to have mediation as the best way to go. And we want to move from the narrative of alternative dispute resolution. It's actually should be the mainstream way, or rather the main means of resolving disputes, not alternative. Litigation is actually supposed to become the alternative. Mediation is supposed to be now the main.
Original
yes.
dispute resolution.
Yes.
ODR, not ADR.
Not ADR. We should be moving away from that narrative.
Thank you. Thank you, Edwin, for sharing your expertise and insight with us. And thank you for your time.
Welcome.